This video aims to explore the question, how were courts used in the United States as part of the Black freedom struggle? The Black freedom struggle contained a legal movement within it dedicated to delivering on America's promises of equality, democracy, and freedom, not just in a theoretical sense, but in a tangible sense, with rulings and arguments based in the language of the U.S. Constitution. The idea of appealing to America as an ideal, as decreed in its founding documents, was heavily present during the 60s and 70s. In 1963, Reverend Martin Luther King Jr. said the following: "When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness." This promise Dr. King spoke of could be and was put to the test in the justice system of the United States. In theory, the justice system is intended to promote and support these unalienable rights. But legality has never equated to rightness, and in practice, the justice system has been one of the most powerful tools of white supremacy and the continued oppression of people of color, especially that of black men in the United States. And yet, there are moments in this history where the courts did make decisions that furthered the cause of black liberation and appealed to the aforementioned promises of America. Cases like Brown v. Board of Education, which declared racial segregation in schools unconstitutional, and Loving v. Virginia, which legalized interracial marriage, are famous examples of successful legal efforts within the Black freedom struggle. Another essential yet lesser-known example took place in 1971, when the Supreme Court made a decision that temporarily paused the use of the death penalty across the country. That case is titled Furman v. Georgia. The case involves a man named William Furman, a 26-year-old from Georgia. One night, Furman, in desperation, broke into a home to rob it. Hearing the homeowner, he began to run away, and as he was escaping, he tripped, and the gun he was carrying discharged, the bullet going through the back door and striking the white homeowner in the chest, killing him. Furman, a black man, was convicted of murder and sentenced to death. His story was one of many brought to the Supreme Court under the case name Furman v. Georgia. The Supreme Court was presented with the question, does the imposition and carrying out of the death penalty in these cases constitute cruel and unusual punishment in violation of the 8th and 14th Amendments? The 8th Amendment bans cruel and unusual punishment, and the 14th promises equal protection under the law. The Supreme Court decided that yes, the carrying out of the death penalty was in violation of the 8th and 14th Amendments. In a 5-4 decision, they struck down the death penalty, not because they believed it was wrong in and of itself, but because they determined it was being used unfairly and arbitrarily. The justices argued that a just society is defined by evolving standards of decency, and that the current use of the death penalty was in violation of those standards. Justice Douglas said, "Under these laws, no standards govern the selection of the penalty. People live or die, dependent on the whim of one man or 12. This decision asked every state to evaluate how they used capital punishment, and Furman v. Georgia effectively ended the use of the death penalty for several years across the U.S. This decision and its result would not have been possible without the teams of highly trained lawyers arguing before the court, from organizations like the NAACP and the ACLU. Barrett Forrester was a young lawyer who was sent to Mississippi to challenge death penalty cases in the 1960s. In his book, Race, Rape, and Injustice, he reflects on how they discovered the almost exclusive use of the death penalty for the past 20 years on the African Americans convicted of rape. A huge part of this case and others was reliant on a body of existing case law and records as precedent, as well as statistics that reflected the highly disproportionate use of the death penalty against black men. The numbers are harrowing. In Texas alone, from 1930 to 1962, 66 black men were executed for rape, while only 13 white men were. In other southern and border states, the ratio of black to white men executed was 11-1, while the simple population ratio of black to white men was roughly 1-9. A years-long federal pause on the death penalty feels like something radical today in a certain sense, and yet it already happened in the 1970s due to this concerted legal effort. And that legal effort only existed due to the larger Black freedom struggle that produced its lawyers, funded its organization, organizations rallied its supporters and inspired citizens, presidents, and Supreme Court justices to wrestle not just with the law, but with justice. It seems as though everything that happened inside of the courtrooms was dependent on the movement that existed outside of them. The relationship between the two is symbiotic, and one is understood in entirety only in the understanding of the other. This history of Furman v. Georgia is a window into a much larger story about this dynamic relationship. It is clear to me that to understand the Black freedom struggle, one must understand how its aims were brought into courtrooms, and also how the struggle itself fueled the individuals and groups that bravely walked into those courtrooms and made strides towards the promise of America.